All right, so we'll go ahead and get started. So hello everyone. My name is Jenna Pecco. I'm an account manager on the Gillsbar team. I'd like to take a moment to introduce Casey. He's a partner of Gillsbar from the BCS compliance team, and he's going to go over some important compliance items. If you have any questions throughout the presentation, feel free to add them in the chat, and if Casey doesn't see them, then I'll bump him, and we'll go ahead and get started. Thank y'all all for coming.
Yeah, thank everybody for joining us today. So, Jenna, am I in control of the slides? I can advance them down here. Is
Yes,
that
you should
working?
be able to.
Perfect. All right. So today, we know employers have been very busy with all the ACA reporting in March and then RxDC reporting responses and updating, material from the new year. And now you're working on probably getting ready to work on 5500s this summer and PCORI fees. And sometimes we just find some of the basics are still not quite addressed and maybe misunderstood. So, what we like to do is talk about the things that come up over and over when we do a compliance review with a client and try to walk through the things the government wants an employer to be doing. But it might be turning out that some of this stuff was lost along the way. And so, we don't want to lose sight of this stuff and we want to make sure that they are addressed as time permits. So, with that, we're going to go through the top 5 things that we see come up over and over in a compliance review. And those are, as you can see on the screen, ranging from HIPAA to ERISA, leave requirements, um, ACA rules on who's eligible when, and then number one is COBRA. So let's go through those one at a time together. But before we do that, we just want to start off with a polling question. We want to start off the discussion asking, how confident are you feeling about those 5 topics you just heard about? And it'll be interesting to see if you feel the same way when we get to the end. Usually, as we go through a compliance review with a client, we start uncovering the layers that the government likes to throw on this stuff. And then your answers or your view may change. So we just like to start off with where you think you are, and then we might revisit this at the end to see if maybe there's anything that you feel, oh, I might have some cleanup to do. So we'll give that a minute. Looks like some pretty good responses. Just over half of you saying you're pretty confident you've got this. So hopefully that's right. We'll dig into some details. Okay, very good. Okay, there we go. Thank you, Jenna. All right. So, at the beginning, we tend to talk about these details because compliance matters. Um, One of the things that we don't want to see employers go through is a mistake that leads to a benefit not being honored or a penalty applying. Sometimes we do run into situations where a law protects things, and so an obligation has to be met. And in order to meet that obligation, we rely on an insurance company to help us or a third party of some sort. And in order to meet our legal obligations, we need their support. Well, if it turns out that something wasn't done along the way correctly, and so there's something missed, and we can't get their support for one reason or another, the employer is left on the hook, and then they're being investigated usually because the person went and complained to the government that I'm not getting what I'm owed. And so the government is coming and asking questions. And so we can find ourselves wanting to make sure that this doesn't happen, but it can get backburnered sometimes. And so the purpose of today is really just to focus on some of these underlying things that come up over and over that really are worth your time. You want to avoid fines and penalties and issues with complying with a law when somebody is protected by the law. We want to avoid the time and money that it costs to correct errors and protect our business from potential fines and penalties and investigations. Protecting your employees is important too, right? These benefits are being sponsored for the benefit of the employees. We want to do them well. We want to establish that, hey, this is important to our culture. This is a value add for your employment with us. We do take it seriously, and we take our fiduciary responsibilities to run a good program for your benefits. And then it just helps to avoid abuse. When you have some consistencies, you have the documentation that you're doing what you should and doing it well, and there's consistency to look at. Everybody's on the same page that the job is getting done and the requirements are being met, and nobody's getting favored or discriminated against in any way. Everything's consistent. So, really important that compliance is front of mind as you operate your benefit programs. And when we talk about that fiduciary duty, sometimes that can be a little hard to understand. We know what this means from a retirement plan context, but this applies on the benefit side too. And there's this duty of loyalty. We have to act in the exclusive interest of our participants and beneficiaries when we're operating the plan. We need to operate like we're a prudent expert of benefits. If we're going to sponsor benefits, we need to actually do the work to know how they should work, what's required, how to maintain them and operate them well. We want to minimize the risk of large losses, and we want to have very clear documentation of exactly how the plan is intended to work, what are the terms, and we follow those. We don't make exceptions all the time. We only make exceptions when warranted, and hopefully address those in the future in the document so that it's not an exception next time. It's something that came up, we addressed on the fly, and now we have a process, we have a procedure for handling it. So, as a fiduciary, really what the goal is under ERISA is that employees are entrusting the employer with a very large part of their benefits and their money, and their health, their finances. And they really want the employer to own that process well, to have really great benefits for them that are meeting their needs, that deliver what's promised, that pay on time, and they don't run into problems a lot. So, there can be some penalties when these duties are neglected or not done to the nth degree. But overall, that's the employer's role. It's not just to sponsor a benefit and make sure the carrier does things. There's a lot more that goes into it. So, with the top five mistakes that we talked about at the beginning that we're going to review, we're going to start with HIPAA. And really, it's privacy and security that comes up quite a bit. Now, the group health plan is actually what HIPAA calls a covered entity, subject to the privacy and security rules. And that's a little bit of an unusual characteristic because the health plan is not an entity. Um, but it is being treated as a covered entity responsible for compliance. So, the entity that operates to run the plan, to sponsor the plan, is really the one that has to take ownership of these privacy and security requirements. Now, when your plan is fully insured with an insurance company, awesome. You tend to be hands off. You might have some minimal obligations, but as an employer, you're pretty hands off. The insurance company is running the plan. You pay a premium, they give you a plan to choose from. You select the one you like, and they run with it. They administer claims, they collect the premiums and pay the claims. They make decisions on what's covered, what's not. They make appeal decisions. The employer really doesn't have anything to do with it, so there's no real need to access PHI. However, some fully insured plans do share protected health information or PHI with a fully insured employer sponsor. That might be for claims analytics, might be large claims reporting, all kinds of good stuff that can be available to certain employers if they engage in a process to address the privacy and security. Self-funded plans are always hands-on. In fully insured plans, you're generally hands off unless you engage with some PHI, like you can get a claims analytics feed or some large claims reporting or something. Self funded plans, you're owning that data. An insurance company isn't owning the plan and running it start to finish. So it belongs to the employer ultimately. And the employer needs to have administrative, physical, and technical safeguards to protect the PHI that ultimately the employer is responsible for. So, the kinds of things that the employer generally has to be sure of when there is a responsibility is that the health plan has entered into a business associate agreement with all of the entities engaging with PHI. We want to make sure those BAAs are kept up to date and they're with all of the right parties. A notice of the privacy practices that are governing the sharing and using of PHI should be given to the plan participants. Now, that's a pretty long notice. It's like about 8 pages. So we don't necessarily need to give this to everyone every year. We can give an abbreviated notice every year. But letting them know that we have a full notice of privacy practices, this step gets missed a lot. When an employer really has to provide this NPP, as we call it, it's a pretty big 8 page notice. We want to make sure that that one is in the mix too, not just the abbreviated notice most employers have. The plans must be compliant with EDI and security requirements governing electronic data information sharing. So that has to be in the mix. And then there's other laws from privacy and financial, medical records, you name it. And then one of the big ones, the federal government has actually started a new initiative this year, a risk assessment initiative to go out and discover when plans do not have a risk assessment of the PHI that's available and what vulnerabilities exist and what processes are in place to make sure those vulnerabilities get protected. That the PHI is protected as it's available, as it's accessed, as it's disclosed, as it's used and shared, even as it's destroyed. Is it properly destroyed? So a risk assessment is a key element. It's like a foundational element to identify what is available PHI, what risks are inherent in having availability and access to that PHI? And let's identify all the ways that we need to recognize that PHI needs protection. What are the risks and how can we protect it? And then, of course, training your staff on, hey, we have to develop policies and procedures on accessing and using this PHI. We want to make sure our staff gets trained on the things that we build as protections, encryption, and when to destroy something after we're done with it. All those kinds of things should be in training. And we generally recommend training at least annually, just to make sure everybody is keeping that stuff top of mind. And then last but not least, we do have down here, you must identify, you must name a HIPAA privacy and security official. These are probably not the same person. Security official has to be very ingrained in cybersecurity, and the privacy official is really taking ownership of the rest, making sure BAAs are in place, that the notice of privacy practices is provided, policies and procedures, all that good stuff. So this is the stuff that we find gets missed a lot in a compliance review with a client. So, if you are finding that this might be a deficiency, just take steps to identify whether you have an obligation as an employer. If you're fully insured and have no access to PHI, you still might be subject with respect to something else that you have that is self funded, like a health FSA or a health reimbursement arrangement or HRA. There might be something in the mix that you do self-fund and HIPAA privacy and security requirements might apply. So double check whether you really are hands-off, fully insured with no access to PHI, nothing else self-funded, then your requirements are pretty light and you should be in good shape. The insurance company is taking care of everything for you. But if you're not truly hands off, if you're hands on with respect to a fully insured plan giving you claims analytics, or you have some self funded plans in the mix, even a health FSA or HRA, we want to identify the risks that we have. Do that risk assessment and identify PHI and who should have access to it, what policies and procedures we should develop, do some HIPAA training, and make sure your BAAs are in place. And then we strongly recommend just having a HIPAA vendor help with this stuff. There are um, sisters out there that do this well and handhold an employer through this. And the good news is, once you've done it, you're good. You generally don't have to revisit this over and over every year, as long as you haven't made any changes. You're not moving from like fully insured to self-funded on your medical plan. That's a time to revisit all this. But once you've set all this up, you're set. So engaging with that HIPAA consultant can be a one and done thing. Next up is under ERISA, having a plan document and SPD. We run into this a lot. And I think one of the misunderstandings out there is these carriers, these insurance carriers, are giving me a booklet to explain how the plan works. Isn't that enough? And I also have an SBC with that table that the federal government wants us to provide. Isn't that enough? And the short answer is no. They do not go into all the details that an ERISA plan needs to discuss. Some examples I like to give are they may not talk about the look back method for an employer that adopts the look back method. They may not go into detail about leaves of absence and how to handle those. And we're going to talk about those in a minute. So there's going to be things where they are a little bit vague and are going to defer to the employer, and the employer needs a document of their own to wrap around what the carriers are giving and fill in some of those key details. And then ERISA has some required language that they want in plan document and SPD, but sometimes that stuff is not all present in what the carriers give. And so if any element that's required of ERISA is missing from those carrier documents, we need to pick up that slack and put that in our own. Now, when we talk about a wrap plan document, that's pretty simply a document of the employers that wraps around all of those insurance policies they're buying, and it incorporates all of them into it. An SPD is just a summary plan description. It's a summary version of the plan document written in terms that the average participant can understand, and it wraps around all of those insurance certificates. And then we do have a closing comment down here that a cafeteria plan or POP is also required in order to be able to deduct things pre-tax out of people's pay. Often when we go through this exercise, we do find that this is accommodated because they have a health FSA and their FSA vendor also put together the POP document for them. But if you don't have a health FSA and you're missing this WRAP plan document and WRAP SPD, then you might find you might also be missing this cafeteria plan or POP. And so that might be a tag along project to work on as well. So if you're not compliant, it's pretty easy to get a wrap document put in place these days. Usually there's some templates out there that you can work with that are pretty low cost. And while you're at it, we do recommend if you don't have that cafeteria plan or POP document in place, go ahead and work on that at the same time. They really go hand in hand and they can come as a package deal. Go ahead and adopt it, you review it, you sign it, you execute it basically, and then you give the SPD version to your plan participants. Participants only really need the plan document version when they come and ask for the legalese, the full plan document version. Usually they are not interested in that. They just want to know how the plan works in language they can understand. On an ongoing basis from there, give the SPD to new plan participants pretty soon after they enroll. And each year after open enrollment, go ahead and make sure within about 90 days after open enrollment, you've contacted each of your carriers, gotten your updated SPDs from them. You've looked through your own SPD to make sure it's up to date. And within 90 days, go ahead and send out a notification to all your employees that, hey, all the new SPD material is updated and ready for anybody that wants to access those. Next up is just making sure our handbook, SPD, and other materials are matching. Sometimes we will find that the carrier has some language that might be vague or says one thing, and then our handbook or our annual open enrollment guide or something else says something different. And we really want to make sure all of our materials are aligned. Now, from a carrier perspective, they might have to be able to accommodate certain things like unmarried domestic partners might be eligible. But it's up to the employer to decide, well, do we allow unmarried domestic partners to be eligible? The carrier says they allow it. Do we want to allow it? So we really want to have things married and speaking the same language. So they may state in a carrier document that 30 hours a week or being on FMLA, you're eligible, where the handbook or leave policy might say something else like um, disability. If you're on short-term disability leave of absence, you get to stay on, even if it's not FMLA. Or ongoing seniority and benefits, you've racked up a leave bank of some sort. Then we have a little bit of a disconnect. You're supposed to be regularly working 30 hours a week, but we have language saying we don't necessarily have to abide by that. We have other rules. So if we say 6 months somewhere else and we say you got to be working full time or on FMLA in the carrier document, we have a disconnect. So we really want to pay attention to leaves of absence. Any benefits that are continued while not actively at work and not on FMLA really need careful attention. FMLA only protects the group health plans, medical, dental, vision, that kind of stuff, to stay intact as long as the employee keeps up their share of the premium. But they do require the non group health plan stuff like life and disability to be able to be reinstated upon resuming full time work. So often employers will work to have those plans stay active as well during FMLA. And so usually FMLA has been fairly well addressed. You can double check what you've got and see if you're looking in good shape. But usually the FMLA scenario is okay. What we're really concerned about is if somebody's a little bit newer and they don't qualify for FMLA yet, or they've already exhausted their FMLA leave, and so when their leave goes longer, or they're taking an additional leave, and but they've already used up their FMLA time, we really want language saying what happens to their benefits and at what point do we move them off of the benefits. So having clear language and some consistency that we apply in those situations is really important. And mainly, we just want to make sure that our carriers are on board with the language that we adopt, whether we're fully insured with an insurance company or we're self funded and we have a stop loss insurer helping to protect us from some catastrophic claims. We really want their buy in. That what we want to land on for letting people stay on benefits when they're not working full time and they're not out on FMLA, we really want their buy-in on where we want to land. If we want to be able to leave people on for 6 months, we need them to be there to pay a claim that comes up in 5 months. And if they won't be there to pay that claim, the employer might be hurting to try to self fund that claim completely out of pocket. So we really want to make sure that we're not putting the employer at risk with unclear language or a carrier or stop loss carrier that's unclear on what your policy is and isn't really agreeable to it. So if this is a deficiency, just make sure to review the materials that you have. Your employee handbook, your leave policies, your open enrollment guide, all those kinds of things should be aligned with where your wrap document and your carrier contracts are saying eligibility is tied. If there's a conflict, make sure to revise what's needed. If that's your own documents, a handbook, open enrollment guide, your wrap, etc., work on those amendments and get that documented and make sure the carrier is agreeable to it. If the conflict is on the carrier side, like, no, we actually allow 6 months to stay on benefits even when they're not working full time, let's make sure the carrier has the right language to support that. And if they can't get there, talk about how to get there. And if that's through documents of your own or through a partnership and understanding with them. So, really important to kind of close those gaps and then have that consistency able to be followed so those carriers will be there to pay a claim. Another big area we see in compliance reviews is ACA misclassified employees. And the ACA for applicable large employers is generally saying you've got to offer coverage to your 30-hour-a-week employees. That translates to 130 hours in a calendar month when people might not quite be at a 30-hour definition. Maybe they're a little bit over, a little bit under, and you're wondering, well, is an occasional week of hitting 30 a problem? The real answer is 130 hours in a calendar month is the metric to be looking at. So we have to offer that. Um, no longer than a 90-day waiting period can apply. So first of the month following 60 days tends to be about the longest we can go. And we want to be identifying the full-time employees correctly. We want to be offering them minimum value affordable coverage on time. And the misclassified ones that we worry about are things like interns, temps that we hire, seasonal employees, contractors that we might be extending benefits to, even though that's really not supposed to happen as much as possible. When we're in a PEO, we can experience some complications. Part-time employees can actually fluctuate into that 30-hour a week sometimes and trip us up. So there can be some situations where we have these populations that we're not sure about and we may not be addressing very well. And so we need to have very clear policies on how we're handling them. And variable hour is one of the biggest problems we run into. These are the people who can fluctuate above and below 30 hours a week. In a hospital or medical care environment, that's PRN. In hospitality, might be servers, bartenders. Um, and so there's lots of examples out there in education. It can be paras, adjunct faculty, coaches, those kinds of things. And even some part timers can occasionally come in and help to work full time for a season or to protect. To fill in when somebody takes a protected leave, those kinds of things. If they're truly variable hour, the employer might want to adopt something called the look back measurement method, where they can average hours over many months instead of being worried about what people work month to month to month. And if their average over time averages out to 30 hours a week, then they are deemed full time uh, for the year after that. Now, most employers do end up needing look back, but not all. So we find about two-thirds of employers need it, and it's important to go ahead and implement that if that's something that you need. And basically, it just kind of depends on how often are people who are not regularly full-time potentially working a 30-hour a week or 130 hours in a calendar month. If there's a good chance that they could hit that metric in 1 or more months, and that, quite a few of them could, we really wanna make sure we're offering the 95% of who we should every month. We don't have a whole lot of room for a mess up. So if these variable hour people can trip us up, it might be worthwhile to implement a look back for these populations. This lets us balance the hours over time, do an average instead of a month to month to month look. And then seasonal employees are defined under the ACA as being hired a set time of year intended to work 6 months or less. If we're an employer that does not adopt the look back method and these seasonal come into work full time, they're technically supposed to be offered the coverage. They're full time. However, if we're an employer that adopted the look back method, we can actually subject them to an initial measurement period under our look back. So the goal there would be hopefully they will work for the season. They will leave for at least 13 weeks before another season comes on, and I'll never owe them coverage because they're under an initial look and they're not around long enough for that initial look, that initial measurement period to run its full course. And when they're gone at least 13 weeks, 26 weeks in education, but 13 weeks for everybody else, then that prior employment is tossed aside. It's not needed to carry forward. When they come back the next season, we can start over with a whole new initial measurement on them. Now, contractors, temps, PEOs, we really don't like to get into deep discussions on this in a call like this requires some one-on-one discussion. We really do look at common law employer requirements and criteria, looking at relationship and how much the employer can control the work and all kinds of things that really an attorney generally is going to see if the employee or the worker is actually a common law employee. We really want to encourage employers to think through this stuff very carefully. Misclassification of employees as a contractor is actually not something the IRS is going to be forgiving on when it comes to the ACA employer mandate. So they really want employers to get this right from the get go and have an attorney looking over these types of positions to make sure they understand what they have and what they're subject to. A temp working full time hours, if they're seasonal, like an intern, we're okay. We can subject them to an initial measurement period if we're a look back employer. But if we're not a look back employer or they're not coming in for a season, we really need to look at them as a full time hire. So just some things that we run into pretty consistently out there. If this is sounding like I might need to take a look, just go take a look at your employee populations and what you have. You really want to make sure you're always offering every month to at least 95% of who the IRS calls full time for that month. So the margin for error is pretty small. The penalties can get pretty big if you mess up on more than 5%. So just determine if you need look back. About two-thirds of employers tend to need it. And so it's possible that if you don't have it today, but you haven't really thought about some of these variable hour or full-time seasonal positions, and maybe that is a problem area in your setup, look back may be something to explore implementing and applying going forward. Make sure you don't apply your own definitions to avoid offering coverage. What we want to make sure we're doing is paying attention to where the ACA says full time status is and following the ACA's rules and aligning our language with what the Affordable Care Act says. All right. So, with that, we've arrived at the number one area that employers tend to make a mistake on. Cobra. And so, usually Cobra's outsourced, and we feel like we should be in pretty good shape. The third party administrator helping us with Cobra, we set up good processes with them. We get arrangements for them to send notices for us. We know how to identify when a Cobra triggering event has happened that the Cobra administrator needs to know about, like a child turning 26 or an employee terminating employment. And so we set up all these processes and we make sure that our timelines, our notices, and all that kind of stuff is addressed well. However, one of the things that we tend to run into, discussed at the bottom here, is group health plans is not just medical, dental, vision. It's all of your group health plans and does include things like a health FSA, an HRA, an on-site clinic, most EAPs, and even ICRAs, and some carved out or bolted on benefits that an employer might bring alongside their medical plan. Think about telemedicine benefits or a fertility benefit, a menopause benefit, a behavioral health supplemental benefit. All these things that an employer brings alongside the medical plan that really can't be sponsored without integrating it with the medical plan are all group health plans. So all of these things are actually subject to COBRA. And often these things are missed, and we focus too much on medical, dental, and vision. So, identifying what plans are subject to COBRA is kind of the error number one that we see. And then number two is this initial notice. So we're all pretty familiar with if a triggering event happens that a COBRA election notice needs to be sent. Child turns 26 or an employee terminates employment. We know an election notice needs to get sent to give them an opportunity to enroll in COBRA. However, there is a COBRA initial notice that's given when people newly join a group health plan. Um, And we can usually get away with having this in the carrier documents, that booklet that explains how the plan works that's given to the employee when they enroll. That has the language in it usually. And then we can also include it in our wrap document and wrap SPD and give that wrap SPD to people as well, and it'll be in there. So from an employee perspective, we're usually okay. We're covered. Employees are getting this initial notice. However, spouses cannot be given that notice in that manner. And so the courts require mailing this to a newly enrolled spouse at home. We can address it to the employee and family. We can address it to just the spouse. Whatever the case may be, we really need to capture when a spouse is newly enrolled in a medical plan or a group health plan and get this notice mailed to them at home. Emailing to the employee, handing out to the employee is not sufficient proof that the spouse has been notified. So, why is this important? Well, it contains COBRA rights and responsibilities information that a spouse needs to know. So, one of the key things that a spouse is going to learn about in there is that if they ever do get a divorce someday and the employee does not come in to timely notify the employer of the divorce, the spouse has a responsibility to timely notify the employer of the divorce within about 60 days in order to preserve their COBRA rights. If they take longer than the 60 days, they lose their COBRA election rights. And because they took so long, not only will they have to go ahead and remove them from the coverage, they're going to have to do it retroactively to the date of the divorce or the end of the month of the divorce because they have technically not been an eligible dependent since the divorce. They've not been eligible. And so there can be, as you can imagine, claims involved when a spouse takes too long to tell the employer and loses out on COBRA and has a big, long retroactive removal of coverage. There can be some claims involved. And so often litigation ensues. And if the employer does not have proof of this notice being mailed to the spouse at home, they don't have a defense in court and can find themselves stuck. They either have to extend COBRA to the spouse and hoping the carrier or stop loss will help them with that, or extending COBRA to the ex spouse and having to self fund all of the ex spouse's claims for the full 36 months. Remember, COBRA for divorce is 36 months. And so 3 years of claims exposure. And so, really important that we have evidence of this notice being mailed to the spouse at home after they newly enroll. And remember, newly enrolling is not just new hires. This can be open enrollment time, they finally add a spouse, or there's a qualifying event, and that's when they add a spouse. So this could be much later, well after a new hire situation. And we don't want to lose sight of those when a spouse is newly enrolling. We absolutely want to make sure that we document this notice being mailed to them. So, what to do if you're not compliant? Really, we just want to focus on outsourcing Cobra to a vendor that does Cobra all the time. They're going to help handhold you through the processes that it takes to do this well, provide notices, to have good record keeping, um, and make sure you're identifying which plans you have that are subject to Cobra. That Health FSA needs to be in the mix. The EAP needs to be in the mix. So don't lose sight of those. Make sure they're a part of the process. They can be treated maybe a little differently than the medical dental vision, but they're still subject to COBRA and part of the process. And then make sure you've got a way to work with your COBRA vendor on capturing those spouses that enroll later, not a new hire situation enrolling a spouse at hire, but qualifying event time or annual open enrollment time, if that's when a spouse newly enrolls for the first time, we need a good process to capture those new enrollments for spouses and make sure they get this notice sent to them at home. And then we're keeping proof of getting that done. So that's where we tend to find our number one compliance mistake in compliance reviews. And we do have just a little bit of a bonus slide at the end here of some general notices to include in open enrollment materials and for new hires, in case that's helpful to you. Notices that tend to not be included in those packets and the reasons why. For example, we just talked about the COBRA initial notice. We don't need to hand that out every year, and we only need to provide it to spouses at home. Everyone else gets it in the carrier document that's given, or our WRAP SPD, or both. So we really need to mail this to the home. It's not appropriate to just put in an annual notices packet. So you could see on this slide all of those different explanations. And so here, I think what we want to do is revisit from where we started. How are you feeling now? Are you still feeling like all of these things are done well for the company, or are some of these things an area to clean up? We'll give you a minute to respond. All right, and Jenna, I might let you take over from here.
Okay. Well, thank you everybody for joining. Just a note that anybody who registered for this webinar will receive a link to the recording tomorrow for you to reference if you have any questions that may come up. If you have any questions for our team, please feel free to reach out, and we look forward to seeing you guys on the next quarterly compliance webinar.
Thanks, everyone.
Thank y'all. Bye.